So, Mr. Dunn, what's the answer to the $64,000 question you posed just before the short adjournment?
Well, it would help or assist, I think, if I recalled exactly where I was in terms of the $64,000 question. I was about to go on to...
Said, how could it possibly be right to say the purpose of the Solicitors Act plus Section 67 and the overriding objective means that the client must have not just a Solicitors Act assessment, but also separate proceedings? That was the question you posed, and I think you were going to show us Section 67.
I'm coming to Section 67, yes, my Lord, and of course the overarching point is that that cannot possibly be right, and if it's a matter of sort of interpreting what the Section 70 says in terms of the statute, then taking into account the purpose of Section 3 or Part 3 of the Act, and taking into account what Section 67 says, and indeed the practice direction, then it can't possibly be right in my submission that essentially the client is completely shut out and is told to go elsewhere, take up more court time, take up more costs. And it's the sort of hallowed phrase of sunlight being the best disinfectant is particularly apt here in my submission because...
Sorry, the hallowed phrase of what?
Sunlight being the best disinfectant is particularly apt here because if one thinks about these Part 18 requests in this context, the answers will either be, there'll be three potential answers. No commission, and in which case it's a Part 18 response, it's been signed by the solicitors, the parties move on and the court moves on, there's no issue. Or it will be, we paid a sum, but it wasn't a commission. Or it will be, yes, we did pay a commission, apologise for the omission, and £50 or whatever is going to be credited in the cash account. So the point, and this is where Edwards comes into play, as I'll take the court to, the point is that the purpose of doing this at this stage is to establish the parameters of what the court is required to do in terms of the cash account. Is there going to be a dispute? And can that dispute be dealt with quickly, efficiently, proportionately at this stage? The final point of sort of general introduction before I go on to the grounds themselves is just to draw your lordship, your ladyship's attention, if I may, and judge, to the authorities bundle at page 669, and it's tab 38, using the paper bundle. This is the
MOJ paper?
Yes, that's right, my lord. So it's the February 2019. I cite this really to make this point. This is not sort of speculation upon speculation, fishing for the sake of it, as can be seen in that MOJ report. And I don't intend to place it higher than it is, but what it says is that the authors of that report have...
page number for us?
Sorry, my apologies, 669, my lord. So this was reviewing essentially LASPO and the reforms that came in post the Jackson report. And part of that was looking at ATE insurance, and particularly in this sort of case, which is a low-value personal injury case. And your lordships, your ladyship will see at paragraph 101 what is said there, that they received some evidence which appears to document the overcharging of PI clients for ATE premiums and by PI solicitors for straightforward RTA cases at prices significantly higher than the cost and or market rate. So again, this wasn't just speculation on the part of whoever had
But how does that help you? Herbert establishes that the amount of the ATE premium cannot be challenged under Section 70.
Yes.
What this paragraph is talking about is too high a price for the ATE premium. It's not talking about commissions or anything like that.
It begins saying that. Your lordship is quite right, but if one looks at the final paragraph it was suggested that the difference between the true cost of the ATE premium and the amount deducted from a client's damages should be fully disclosed as a form of commission, directly or indirectly. I say that really to make no more than the point that this isn't a sort of a wild stab in the dark in respect of these cases. There is concern that there are commissions being utilised as part of these premiums, and that they are not being disclosed. And ultimately, as I say, that is all that was trying to be established in this case. So looking at the Part 18 questions themselves, they're in the core bundle at page 19 to 21. And they're under tab 2.
3, I think, in my bundle, isn't it?
Some of the numbering slightly changes, so if I'm saying numbers that don't sort of correspond, do let me know, as I'm sure your lordship's and ladyship will. But what the former client sought to clarify was essentially 3 things. Basically, the name of the insurer, date of the inception of the policy, and the identity of any intermediaries involved, whether the premium had been paid to the insurer and the date of payment, and whether any direct or indirect payment had been made to the solicitor from the insurer or any intermediary. Now, I accept the point that I'm having to deal with is a technical point about the scope of what the proceedings are. But I do repeat that it is surprising, to say the least, that a firm of solicitors who owe a fiduciary duty to a client steadfastly refuses to answer those questions. And their response to those questions is, you'll have to essentially sue us elsewhere. That's essentially what they're saying. If you want to get those answers, that's what you'll have to do. But I accept that that doesn't answer the question my lady put to me this morning, which is, if that is an unattractive position to be in, I still need to make good the point that it's within the proceeding. So I'm not shying away from that. The cash account itself hasn't been looked at yet, but it's in the supplemental bundle at page 101. And if I could just ask the court to turn that up, because it is instructive in my submission. One can see it's a table which includes a number of different elements. So it isn't just, for example, the payments on account that the client has made. And it includes, for example, the damages that have been received. It includes the ATE payment. But it also includes, as an example, the costs received into parties from the other side. And I'll develop this point, but as a sort of placeholder, I ask this question. If all that the cash account is for, and all that is required is for, as the solicitor says, is essentially for the judge to look at what's been paid on account and then what the bill's been assessed at, why are all of these other items included in the cash account? And why are items included in the cash account that are no part of the bill? rather confusingly, and this may be just my confusion, but there does appear to be reports which are disbursements which are in the bill, should be in the bill. So I'm not sure why they're in there, but those
Well,
are
that's because it shows the money that's coming into the account and what's actually gone out of the account. So if you're looking at the amount of cash that's gone through the account, then it will include matters that are not part and parcel of the bill.
But my lady, it shouldn't, because the cash account should only include items which are not included within the bill of costs.
Well, these aren't.
The disbursements for expert reports would be included in the bill of costs. It's not a point I want to dwell on, but I just make that as perhaps learned cost judge will be able to assist on that point. So we start at section 70 of the Solicitors Act, and the call's been taken to this, but I want to go to it just to make the point as to what is required under the statute.
I'm sorry, I'm behind you. Where are we going?
My apologies. It's authorities bundle, page 5.
Yeah.
And this is section 70.
It starts on page 4.
Yes, my lady's right. So this is section 70, begins on page 4. And section 70, bracket 70, requires, as can be seen, the costs officer to assess not only the bill, but also the cost of assessment, and to certify what is due to or by the solicitor in respect of the bill and in respect of the cost of assessment. So, as a starting point, what is required is the cost judge to certify, and certification, in my submission, I've made a point about how one should interpret the Solicitors Act as a Consumer Protection Act, but certify cannot simply mean rubber stamp or wave through. It has to certify, must imply that there is some engagement with that question. And the only way that the court can determine, and I have to say I don't think this is in dispute between my learned friend and I, the only way the court can do that, i.e. work out what is due to the solicitor or from the solicitor, is by taking the assessed bill amount, cost of assessment, and then the cash account, and totalling those up and seeing who owes what to whom. That's the process by which that occurs. You
accept that the certification is what is due to or by the solicitor in respect of the bill? Yes.
I do accept that, but my lady, the point I say in respect of that is if the bill has been assessed at £1,000 and the cash account shows that a payment on account has been made of £1,100, which happens a lot in solicitor-client assessments, the client's often paid more than the bill is ultimately assessed at, then by working out what is due in respect of the bill, that necessarily involves looking at the cash account and determining that, well, nothing is due in respect of the bill and there needs to be an order flowing. That's really my point about that.
Well, I don't think there's anything between you that you look at the cash account to see how much money the solicitor has received for his fees, or which is the client has agreed can be appropriated towards the fees, and then you do the maths.
Yes, my lady's right. But what is in dispute is that what is said against me is that when one undertakes that task, all one is looking at is essentially what's been paid on account by the client, and then what's been paid, and that's where the parties part ways. So my lady is quite right. But if one looks at, there is helpful guidance in the practice direction, which is in the authorities bundle, and it's at tab 6. And at page 114, one can see it, practice direction 6.6. It shows that the breakdown of costs referred to in Rule 4610, and that is the standard order that's made on detailed assessment 4610. There should be details of the work done on each of the bills sent for assessment, and B, in applications under Section 70 of the Solicitors Act, a cash account showing money received by the solicitor to the credit of the client and some sums paid out of that money on behalf of the client, but not payments out which were made in satisfaction of the bill or of any items which are claimed in the bill. So that is setting out what has to be included in the cash account. And that is why when we look at this cash account, there are, as I said, the example is the ATE premium, but there's also the example of the inter partes costs that have been paid. Now, if it was right that all the cost judge is considering is a straightforward, what have you paid on account and what is the bill, there would be no need to specify 6.6b in these terms, because it is money received by the solicitor to the credit of the client, for example. So that doesn't include just payments on account. That includes, for example, inter partes costs payments. And also sums paid out of that money on behalf of the client. So that is why sums that are paid out but are not included within the bill, the ATE, for example, is included in the cash account. There's no the narrow interpretation of what the cost judge's task is does not sit at all with 6.6, because if that was all that was required, that part and indeed the statute itself would simply say cash account showing payments on account made in respect of the items of the bill, and that's it. That's all that would need to be set out in the cash account, but that's not what is set out.
I'm not following that.
So if it was right that the task of the cost judge at the end of the assessment or after the assessment hearing was simply to sit down and say what has the client paid on account and what is the amount of the bill, and if the cost judge was confined to those two questions, which as my understanding is what is being said against me, then there would be no reason for the practice direction to spell out other items which must appear in the cash account.
I don't think that is what's being said against you. I think what's being said against you is that the cash account must do these things that 6.6b says it must do, and the task of the cost judge is to see what it is that remains at the end of that account,
Yes.
taking into account what has been paid on account of the bill. But if, for example, the cash account were to record the receipt of £25,000 in damages,
Yes.
and payments out of 10,000 for whatever reason, there would then be a balance owing to the client of 15,000, which would be taken into account when comparing the two.
But my lord, what if that is disputed? Is my point I would raise. If that's disputed, as I understand what's being put against me, in those circumstances, the cost judge, because that's not a matter for items in the bill, does not have power to adjust the cash account in that circumstance, if the appellant's right.
Where do you say the power to adjust the cash account comes from? Well, where in the rules does that come from?
My lord, it comes from 6.19, which is on the next page, 115, and it's the highlighted section. So there's the certification in the statute, there's the wording certification, which I've made my submissions on what that has to mean. But here it says the court determines the result of the cash account. And again, the court determines the result. There's no narrow description of what the court does. We know it has to be accepted that the cash account includes items which are not within the bill, necessarily. In fact, it should only include items which are not within the bill. It's mandatory, so the court will, it's mandatory at the end of the assessment to determine the result of the cash account. So it cannot be right that the determination or the certification of the cash account is simply the cost judge sitting down and saying, you've paid X, I've assessed at Y.
Why not? That's what determining the results means, as a matter of plain English.
It's quite interesting wording.
Yeah.
Determining
The result is the end. It's not determining how you get there. It's not determining any disputes that are on the way to getting to the result. It's determining the results. The result is X amount of money is either due to the client or due to the solicitor.
If there is yes, but if there is a dispute between, so let's not take the ATE, although we could take the ATE, but let's, for an example, this cash account includes payments made in respect of costs from the opponent, fixed costs, for example. If the opponent had paid those fixed costs, but they were not accounted for in the cash account, by determining the result of the cash account and certifying it, the cost judge has to, in my submission, would have to, if there is a dispute, inquire as to whether the cash account is correct. If the claimant says to the solicitor and before the cost judge, when the determination of the cash account is made, hold on a moment, you've received X from the other side, that needs to be credited to me in the cash account. And the solicitor says, no, I didn't, then that is a dispute as to the cash account. It cannot be right that the cost judge can determine the result of the cash account without determining that dispute. And otherwise, the wording would be different. The wording in my submission would be record the result. Recording the result is passive. Determining the result is an active process, as is certification or certifying. Let's take my example that I just gave. If the appellant is right here, then at that stage the client turns round and has said, you received X in fixed costs, you didn't credit me. Solicitor says, no, I didn't. Even if the client then produced, well, here's a letter, you emailed me to say you did receive it. According to the appellant, nothing could happen.
I see that.
Yes, the client would have to then start their own Part 7 proceedings.
The same would apply if the cash account included something for which the bill had already claimed.
Yes, indeed.
Or if it said that the client was awarded £10,000 damages when in fact the client was awarded £15,000 damages.
Indeed, my lord's right. And of course, that is why when one looks at the purpose of why the determination of the cash account is there as part of the proceedings, the final part of the proceedings, save for the final cost certificate, it's there precisely for this point, that you have a solicitor and a client, and there is what the cost judge is doing is determining ultimately in the final cost certificate who owes what to whom. So it cannot be right in my submission, and it can't be in line with what the purpose of either the statute or of the CPR was or is, that essentially a client, a consumer of legal services, is essentially stuck and has to go elsewhere. In terms of overriding objective, that would be a remarkable way, in my respectful submission, to interpret what is being the task of the cost judge, because all it does is lead to increased costs and increased court time. I want to deal, if I can, with the case, very briefly, if I may. Cooper and Hewitt, which is at tab 9 of the authorities bundle. Your Lordships, Your Ladyship, Judge, you have my submissions on the fact this wasn't before the court. I'm not going to repeat those. Dealing with the substance of it. What my learned friend relies upon this decision is to essentially preserve what is said in Jones and James, because it is said that Cooper and Hewitt cites Jones and James, and Jones and James supports, it's said, the appellant's argument. But it's important just briefly to consider Cooper and Hewitt and the facts of it. But before doing so, my Lord Justice Lewison made this point. This wasn't even under the 1843 Act. This was a bill that was assessed before the 1843 Act. So we're not even talking about an antecedent act. The 1843 Act is not before this court, but there are obvious difficulties with potentially relying on authorities where it is a precursor to a later act, particularly in my submission where the CPR, the practice direction I've taken the court to, sets out in the clearest terms what a cash account is, what it's required to include, and what the cost judge is required to do in terms of determining. So none of this is relevant in that respect. And in my short submission, it just can't be supportive of the general point that's being made. I don't say that's fatal to my learned friend's argument, but it can't be supportive. But what's interesting about Cooper and Hewitt is, and you can see this, the court can see this, page 133. The second paragraph, or third paragraph, begins after the master. After the master had taxed the bills under this order, Brooks, who was the solicitor, was examined on interrogatories as to monies received by himself and his partner on account of the petitioners, for which the latter were entitled to credit against the bill of costs. And all that Cooper and Hewitt is saying is essentially, it was an appeal by the solicitor saying that was wrong, I shouldn't have been asked questions about this. And the court will see at page 134, and it's 365, the court disagreed. The court says that the Lord Chancellor says the order was obtained as of course is in the usual form, containing amongst other things a direction that in the case the master shall find the solicitors have been overpaid, they shall refund. He is therefore to inquire whether the bills have been overpaid. Now I don't see how it is possible for him to ascertain that without an inquiry as to the sums which have come into the hands of the solicitors in that character, because these are sums which the solicitor would have a right to retain until he was paid the amount of his bill, which in other words would be applicable to the payment of the bill, independently of any express agreement or appropriation. So here you have the solicitor. So the cash account in that respect is looked at, but the solicitor is examined in that matter. So this far from suggesting that it's a rubber stamping exercise or a simple arithmetical exercise, this is a case where the solicitor is directly asked questions about the amounts. And the path I've just taken the court to is clear. How is it possible for him, namely the taxing master, to ascertain without an inquiry as to the sums which have come into the hands of solicitors in that character? Because they're the sums which solicitor would have a right to retain. So what Cooper and Hewitt is showing that certainly prior to the 1843 Act, the practice was that not only was there a significant consideration permitted by the judge where a cash account was disputed, where it was here, but that went so far as to be examined on interrogatories as to the monies received.
It's simply an inquiry as to how much the solicitors have got.
The interrogatories were not a cross-examination.
No, I accept that.
Simply an asking of questions. How much money have you got on account for this client?
Well, that is not, well, I would submit that's not precisely what it says. It says the inquiry is to the sums which have come into the hands of the solicitors in that character.
Yeah, in that character being for the client.
So, going back to my example of a cash account which doesn't include the fixed costs payment from the other side, I say that the court, if that's disputed, I say that the cost judge cannot certify or determine the cash account until that dispute is resolved. Here, it's precisely the same thing is said. So it's not the case that all that happens, even taking into account that this is pre the 1843 Act, it's not the case that what happens is that there's a recording of what the cash account says. If there is a dispute as to the cash account, in terms of sums, and again, I've used the fixed costs example, there would be questioning of the solicitor.
Well, isn't all it's saying is effectively there has to be a cash account?
Well,
At this stage, that concept isn't being specifically referred to in those terms. This is saying we don't just make an order for payment of costs. We have to look at how much money the solicitor has.
Yes, and my lord, your lordship's quite right, because at that stage we didn't have, for example, the practice direction which set out specifically what a cash account had to include. And we didn't have the practice direction which set out specifically that the cost judge was to
Well, you
determine.
don't have Lee and Neville at this stage. Lee and Neville comes in, and that's where you first see the understanding of the concept of a cash account.
Yes, that's quite your ladyship's quite right. But the CPR practice direction, I appreciate it's practice direction, but the CPR practice direction defines what a practice direction, what a cash account is in modern times, and sets out the task of the cost judge. And it's only if, again, one has to. I say, if you're against us on this point, and what is being said is that it's such a narrow task, one has to ask why you include other items within the cash account. What's the point? I would ask, and also why there is the language of certification or certify, to be fair, and determining. Why is there active language rather than passive language? Because the rules could quite easily say the solicitor must show an account of how much has been paid on the account, and the cost judge will order that the balance after assessment is to be paid. I mean, that's what the rules could say, and that's what they would say in my submission if the appellant was right.
Isn't that what they do say? Because what they say is that what the assessment is of profit, costs and disbursements. It doesn't say there shall be an assessment of or inquiry into cash account. In fact, the revenue cash account is the assessment.
Yes, my lord's absolutely correct, but that goes to the point about whether the assessment, the mechanics of the assessment, is the totality of the proceedings. Because in my submission, the proceedings are involve more than just the mechanics of the assessment. And if the assessment itself, which is the cost judge going through the bill, is it reasonable, is it not? If the assessment itself was the only task of the cost judge, then there would be no reason to have a cash account which it needs to include non-billed items. Why would there be in those circumstances? Because
of Cooper and Hewitt, which says that you don't just work out the amount, assess the costs, because it would be ridiculous to order costs to be paid to a solicitor who's already holding money.
Yes.
So it's just simply reflecting that, isn't it?
So the example, but the problem with that submission is my example of the fixed costs being paid and not accounted for is precisely, if the appellant's right, of a nature which they say the cost judge cannot interrogate the cash account and intervene on. Because that is not sums that have been paid by the client. It's not recorded in the client's payments by the client. It is paid by a third party. So
It's paid by a third party, but for the benefit of the client, it's no different from the suggestion that there's money that's come in, the £500 in Cooper, that comes to the solicitor, which he is entitled to have a lien on for his costs. And so it has to be brought into the overall accounting process because, as the court says in Cooper, it would be ridiculous for the client to have to pay over the £100 and then get his £500 back separately.
But that is, in my submission, a far wider interpretation, even if you're still against me, far wider interpretation than the appellants are contending for. Because now we're in the position where it's not just payments on account that the client's made that are looked at and determined by the cost judge. It's also any payments by third parties or otherwise which were for the benefit of the client.
No, I don't think that's what Miss Bedford is saying. I think what she is saying is that the cash account, the result of the cash account, tells you whether there is anything due to the client or anything due from the client. I think it would have to be to the client, so I don't think cash accounts can go into overdraft.
There can be a debit figure so that when the bill's assessed, the cost judge says, well, the client has to pay pay the balance, yes.
But the point of the result is to see whether there is a balance in the client's favour, which can then be applied towards the assessed bill.
Yes.
I think that's all she's saying.
Yes. So there would be, for example, if there was a commission that was a secret commission and not payable. Take, for example, the Part 18 request is answered and it doesn't even get to a formal application. The questions are asked. Solicitor comes back and says, yes, you're right, £50 of this premium was a commission. We should have disclosed it. Apologies. What does the solicitor do there? The solicitor there credits the £50 in the cash account because it's monies that the client has paid but that are not payable, should be taken from the final balance. So that is no different. I mean, it's a different species of disbursement. But how is that different in any sense to a payment of inter-parties costs, or how is it different to a payment of damages which are too high? The argument is that by not answering that question, so if the question is answered, there will either be, as I say, a dispute ongoing, or there won't be a dispute anymore because it will be credited to the client. Once it's credited to the client, the cost judge's task in determining the cash account necessarily has to include the £50 that's now credited.
What you're really saying is that this isn't just an assessment, it is actually the taking of an account as well.
My submission is that as the proceedings include an assessment of the bill, but the proceedings are not limited to an assessment of the bill.
Well, Section 70 is all about assessment of the bill, isn't it?
Section 70 is all about...
And why should that process involve, without expressly saying so, taking of an account that you would not get in non-solicitor agency situations, including the example you gave for?
Yes.
It just doesn't seem to be provided for in either the rules or in the authorities, that there should be a broad obligation on the court to account to the money held or ought to be held by.
Well, what is the cost judge doing in circumstances where there has been payment of fixed costs that hasn't been accounted for in the cash account? If it's
Well,
if,
as a matter of practice, one imagines that if that point was raised, then a cost judge might, for example, adjourn the matter for the solicitors to look into it. But that's a different matter, and I defer to those with hands-on experience of that.
Yes.
But the fact that it may be pointed out that the solicitor may have made an error in the accounting exercise doesn't necessarily mean the cost judge has to embark or is entitled to embark on an accounting exercise. He can point these matters in the main, which something like that, a failure to include an item or too much or whatever, is something which would probably be capable of being resolved pragmatically.
well,
Does it mean that without saying so, Section 70 in the rules requires the solicitor with this cash account to undertake the sort of accounting exercise which would otherwise require formal processes under Rule 64.
well, yes, but the purpose of the requirement to determine, in my submission, is precisely so that the parties are left at the end with a final cost certificate which tells them exactly who owes what. Now, it's not in my submission.
In terms of costs,
Well,
who owes what in terms of costs? That's what it's about. It's about how much money should the solicitor now be paid in relation to the costs that are, or solicitor disbursements which are part of the costs. And that involves an assessment of what he's already been paid for that, for his services. But it seems to me that the question of whether or not he's taken a backhander on a some kind of insurance premium doesn't answer that question at all.
it answers well. I would respectfully push against the proposal that the point being put to me that all that's being done is to determine what is payable in costs. That's not, because, for example, if there has been general payments on account and if there has been third-party payment of costs, if there has been a disbursement which has been refunded, if any number of items could occur. What the cost judge does is I completely accept that she does say this is the total of the bill, but the cash account is not the totals of the bill. As we can see, the cash account is everything else, all the monies that have passed to and fro.
Doesn't affect though. I mean, I take your point that the practice direction indicates that there are other items in the cash account.
Yes.
So we've got to stand back and actually see what this process is designed to achieve. And what this process is designed to achieve is to work out how much, if anything, is due to the solicitor in respect to the services that are rendered, taking into account whatever the solicitor's already been paid, or whether there's any money that's due back the other way from the solicitor to the client. But it's in respect to those costs.
Well, that's
It's not about accounting for secret profits.
but that's precisely the purpose. My point about the purpose of the Act and the rules, because if the purpose of if we're dealing with a Solicitors Act which is designed to protect consumers.
In relation to overcharging.
No. Well,
that's what it's all about. It's not a general consumer protection piece of legislation like the Consumer Protection Act. There's nothing in the Solicitors Act that talks about secret profits.
there is, for example, it's not, in my submission, it's not simply about, self-evidently not simply about whether someone's been charged too much. For example, under the contentious business agreement provisions of the Solicitors Act, there are all sorts of provisions which provide protections which are nothing to do with quantification of costs. There are entitlements of clients to seek, for example, a cash account under freestanding right to seek a cash account, those are not to do with simply quantification of the solicitor. So it's not simply that that all the Solicitors Act is doing is providing the mechanism by which there can be quantification of a bill. It applies to a plethora of rights across for consumers, and it was of course brought in at a time when there wasn't the Consumer Rights Act and other acts. So it is, and this is the point that the Supreme Court made in Menzies. It is about protecting the consumer. But
So which bits of the Solicitor Act have the freestanding right to ask for a cash account? I know the CPR does, but you said that the Act does.
yes, it might actually. I may have misspoke because it might be in the CPR rather than the. There's an ability to make an application simply for a cash.
CPR Part 67.
Yes, that's
1
yes.
and 2.
Yes, 67(2).
So you can bring proceedings
Yes.
to obtain an order for a solicitor to deliver a cash account.
Yes. Yes.
But that's different, according to the rule, from proceedings under Part 3 of the Solicitors Act relating to the remuneration of solicitors. So those are separate proceedings for an order to deliver a cash account.
Yes.
And you get the same thing in 67(2).
These rules, so scope and interpretation at 67(1), these rules, this part contains rules about the following type of proceedings under Part 3 of the Act. So, for example, delivery up of a bill is under Section 68 of the Act. So all of the rules in Part 67 are specifically rules relating to Part 3 of the Solicitors Act. So the power to make an order to deliver up a cash account is not separate from Part 3 in my submission.
But once you've got an order
Yes.
requiring the solicitor to deliver a cash account,
Yes.
if you want to bring proceedings for an account, you do that under Part 40, do you not?
Yes, and this is, my lord, this is what I wanted to come back on this point because my point really was to do with the difference or what the task of the court is under the determination of the cash account or the certification of the cash account, because it's been put to me that it's not the taking of an account, which would be a Part 40 claim. I accept that. But if one considers the fact, just the fixed cost example, one considers that cash account doesn't account for it. Client says they've received monies from an insurer for part of their costs. Solicitors say, no, we didn't. There's the dispute. The court cannot certify or determine the cash account until that dispute's resolved.
Are you going to put the solicitor in the witness box and cross-examine him?
In those circumstances, the determination of the cash account couldn't be resolved.
The answer to my question is?
The judge would probably ask questions of the solicitor, no doubt, just as in the Cooper case happened. But
Well, that was the service of interrogatories, which are done on paper, but do you envisage that in a circumstances where you've got a factual dispute of that nature, you'd actually have to put the solicitor into the witness box and ask him whether or not you received the money?
in those circumstances, this is entirely what the Edwards case was dealing with. Just one point before I come on to answer your ladyship's question, because that is precisely the point about Mr. Justice Rich's decision in Edwards. But in my submission, the determination of a cash account and the taking of an account, it is simply the method by which a former client and a solicitor in Solicitors Act proceedings is able to have a certified account. of what they've paid and what's been paid out. That is the process. That's the point of it. That's what it's designed for.
So just to be clear, are you saying that the determination of the cash account and the taking of an account, sort of Part 40 type, are the same process or are different processes? And if so, what is the difference between them?
They are analogous.
Analogies.
So the purpose of the Act is that there would be at the end of an assessment, there is a straightforward way in which the cost judge can determine who owes what to whom.
That sounds as though they are the same thing.
Well, if one considers what in all of these examples that I've been giving, if one considers what the cost judge is doing, it's difficult, I would put in my submission, it's difficult to see the difference, qualitative difference between what is happening when the cost judge determines the cash account and what is happening under Part 40. Now,
So they are the same.
they are the same, but it would be a summary procedure in the assessment. That's really the difference, because taking under account an account, you may have cross-examination, there may be all sorts of other issues. But to put the point in another way, and obviously the way that I think is better for me, is to say that if one really focuses on what the cost judge is doing in terms of the task that he or she is undertaking, is there a qualitative difference between the conclusion that the cost judge reaches and the conclusion that, for example, a chancery judge would reach in a Part 40? There may be a difference in terms of a summary process versus a more elongated or prolonged process, but in terms of what is being done, it is simply that they're being shown an account and questions or disputes will be raised about that account, and those are resolved by virtue.
It places me as if there is this form of fast track Part 40, it was actually spelt out in the rules.
Well, this is why, my lady, I want to go to Edwards. And this is at tab 31. At page 542 of the authorities bundle, this is the paragraphs at 219 onwards, which troubled the court this morning in terms of what Mr. Justice Ritchie was ultimately seeking to do. And I hope I can shed some light on this, because what Edwards says, and it's an extremely practical, in my submission, and logical judgment, because it says if there's a dispute about the cash account, then if it is a matter which can be dealt with by the cost judge in the summary procedure of determining the cash account, then the cost judge may decide that he can deal with, or she can deal with that point. If, however, it is a matter where there is significant factual disputes between the parties, it may be that it would need to be dealt with elsewhere, because it would need, for example, this is why Mr. Justice Ritchie talks of being suitable for the Chancery Division. So what is proposed, and correctly in my respectful submission by Mr. Justice Ritchie, is that the Part 18s are answered. The parties determine whether there is still a dispute. The cost judge then considers the matter and case manages. Is this a matter that is suitable for me to deal with as the cost judge as part of the summary process of determining the cash account? Or is it so involved and complex that I have to go elsewhere?
That is all premised on an assumption that there is power to deal with it summarily.
Yes, my lady, you're quite right, and that falls back to the interpretation of what's certified and what determining.
Yeah, I mean, it wasn't an issue before Mr Justice Ritchie, was it?
No, I don't think it was.
I don't think anybody sought to argue in that very long case that it didn't fall within the parameters of an assessment under Section 70.
What was argued is that the and this was the Jones and Richard Slade case that my own friend took the court to.
Yeah.
Was that the cost judges don't have the power or jurisdiction to deal with issues of breach of fiduciary duty, for example. And so what Mr. Justice Ritchie essentially says is that what you don't do and what you can't do, and as I say, my specialist is right, what you can't do as the cost judge is simply say, well, there's this dispute, but I'm going to certify this and I'm going to determine the result of the cash account and I'm going to issue a final cost certificate, even though there's a dispute between the parties. And then leave the parties to their own devices to go elsewhere and start new claims about £50. What Mr. Justice Ritchie says is that you answer the Part 18s and then the cost judge determines whether it's suitable for determining the cash account as part of those proceedings, or if it's not. And that's the practical effect of what Edwards says. What's put against me is that the client is cut off at the first hurdle. It falls at the first hurdle because you don't get the Part 18 answered, and so you never know. And so you have to.
Although the Court of Appeal didn't say so in terms in Herbert, didn't they envisage that challenges to the ATE premium would simply fall outside Section 70?
They certainly, well, yes, that's a fair. There was a concern, certainly, from the Master of the Rolls in his judgment. It's probably worth just me being.
On your argument, the ATE premium, challenge to the ATE premium, whatever that challenge is, gets pulled back in again at the moment when the cash account comes to be determined.
No, I don't say that, and that's part of the, as I just took the court to, that was part of what Mr. Justice Ritchie was saying, that you can't have an assessment of the ATE premium via the cash account. I accept that you don't have, because what an assessment is, I as the client cannot say that ATE premium is too high, it was excessive, and it should be reduced because it's unreasonable.
Which is the MOJ's concern in the paper you showed us, or at least one of their concerns.
Yes, because they were also, their concern is that, the disparity is to do with undisclosed commissions, or potentially to do with undisclosed commissions. So I accept that what Herbert, the result of Herbert is that I as the client don't have the ability to have that as part of the assessment. I can't simply say to the judge, it's too high, it's unreasonable, reduce it, please. But this is not part. So I'm not asking what the client is doing is not asking ultimately if the Part 18 was replied to and if there was still a dispute. It's not saying that there should be a reduction because it's unreasonable as part of an assessment. It's saying as a cash account point, if there's an undisclosed commission, that is a commission which should be credited to the client and therefore should be, as part of the determination of the cash account, must be accounted for. So it's not part of the assessment itself. And this is the difference between, and I'm coming to this point, but this is the difference between what the assessment is and what the proceedings are. Because I don't accept that the mechanics of the assessment, going through the bill item by item, determining what is reasonable and what's not reasonable, is the entirety of the proceedings. I don't accept that. The proceedings require extra steps, additional steps, and proceedings in solicitor-client matters often turn on matters which are nothing to do with the assessment of the bill. Just on that point, while I'm there, if I may ask your lordships, your ladyship, Judge, to turn back to section 67
I'm not sure
Which is
we've
the
got
page-
section 67.
Part 67.
Part
Part
67?
67, my apologies, Part 67. It's page 123 of the authorities.
Yeah.
It's a short point, but it was put that the claim form itself didn't refer to Part 67 on its face or any other part of the proceedings, and the claim form itself was for the assessment of the bill. Now, Part 67 refers to all assessments under Part 3 of the Solicitors Act, 67(1)(b). It also refers back to Part 46 and 6.4 and 619 of the Practice Direction. May I turn my back for a moment?
I don't think that was quite the point I had in mind. What the point I had in mind about the form of the claim form
Yes.
is that subsections 5 and 6 of section 70 seem to envisage a more limited process, or at least that you can limit the process of assessment under section 70, and that paragraph 2 of the claim form was such a limitation.
Yes, that is a different, if I may say so, a different point, because what is being, your ability to limit under section 70 brackets 5 is about not being required to have an assessment of the entirety of the bill. So you can, if disbursements are not objected to, you can ask the court only to assess the profit costs. But that doesn't mean, in those circumstances, that the cash account doesn't need to be delivered, which it does, and it doesn't mean that the court won't undertake what they're required to do under section 70 bracket 7, certifying, or under part 46 in the Practice Direction. And you can see that in this case, because in this case there was a limited request for an assessment, but of course a cash account was served because it's understood by the parties that the determination of the cash account follows. And in fact, the order of the standard order, which includes a standard order, which is at supplemental bundle, page 89. The court will see that the cost judge at 2 and then at 4. So at 2, the cost judge makes the standard order, which reflects section 70 bracket 7 of the Act, which is the requirement to certify what is due between the parties.
Sorry, where are you looking at?
Page
89.
89 of the supplemental bundle.
Yeah.
This is Judge Rowley's order.
Yes.
Yes. So at 2, that's the reflection. These are the standard directions. That's the reflection of section 70 bracket 7, which
Yes.
requires certification. And then at 4, there's the requirement to serve a cash account.
Yes.
So the standard order includes both elements. It includes the requirement to serve a cash account and includes the fact that the court has to certify. And of course, as the court has seen from Part 46, there is the requirement to determine. The real question in respect of whether, if we come back to reverse back to whether these Part 18s were served in respect of an issue in dispute within these proceedings. And again, there's a very restrictive way of looking at this and interpreting the rules and the statute, which is to say that the proceedings are the assessment itself. That's what the proceedings are. And that conclusion will inevitably lead to the client having to go elsewhere and incur further costs before this is all resolved. But it isn't right, in my submission, that the proceedings are only concerned with the mechanics of assessing the bill. And that is obvious, firstly, from the standard order made that that the court's just considered, because that says after the assessment happens, there will be consideration and certification of what sums are owed. It's also clear because Practice Direction 46 absolutely requires the court to determine the cash account in these proceedings. So the proceedings are not the mechanism of going through item by item and determining whether they're reasonable or not reasonable. That is part of the proceedings, certainly, and it might be the main part of the proceedings, but there are other elements to the proceedings. For example, there is the determination of which party is to pay the costs of the assessment under section 70 brackets 9. And that obviously goes back to the 1/5 rule. And that can go back to the totality of the bill and all sorts of interesting arguments about what the bill is made up of, etc. So that is part of the proceedings, because the cost judge is required to determine the cost of assessment as part of the proceeding. Now, the costs of assessment are no part of the bill, no part of assessing the bill at all. Nothing to do with it.
Provided for by the statute.
My lord.
Provided for by the statute.
Yes.
As in terms that that's what the cost judge must do.
Yes, but as is section 70 bracket 7, the certification of the cash account. Yes, that's my point. That there are elements of the proceeding.
Sorry, section 70 subsection 7 doesn't mention the cash account.
No, it doesn't. The practice direction at 46 does, but this comes back to my point, which is that in order to certify what is due,
Yeah, I follow.
yes,
The judge must satisfy himself about the accuracy of the cash account.
Yes, you have my point.
If there is a dispute about something in court proceedings, one would expect the rules, would one not, to say something about how that dispute is to be raised. I mean, in an ordinary civil litigation, it would be by way of a statement of case. Claim form, particulars of claim, followed by defence and all that of it, and that would then tell you what the dispute was about.
Yes.
If there were a factual dispute about the contents of the cash account, I would a priori have thought that there would be something in the rules that tells you how you raise that kind of dispute. But when I look at CPR 47.9, I find that the only provision in the rules for points of dispute relates to items in the bill, not the cash account.
Yes.
If your interpretation is correct, I would have expected the rules to say any dispute any item either in the bill or in the cash account, but the rules don't say that.
The answer we say to that is this: it's not argued in front of this court that the judge doesn't have the ability or shouldn't have, who shouldn't adjust the cash account if there is a dispute. What is said against me is those disputes are confined, narrowly confined. So there isn't, using that logic, there isn't any provision for disputing the cash account, even as it relates to, for example, the fixed costs that have been paid or sums that have been paid on account. It seems to be accepted by my learned friend that, for example, if there has been in the cash account, if it doesn't reflect the true amount that's been paid on account, that the cost judge, that can be disputed and the cost judge will determine that. So that's accepted. I'm widening that, I accept. But if that logic was correct in my respectful submission, there would have to be provision for that to occur. And everyone, certainly this side, everyone appears to agree that that can happen. So I do take that point, but that may simply be a reflection of the rules, and it may be that the provision which says the cost judge must determine the cash account is clear, that if there is a dispute, it must be determined. My Lord's second point is an important point, because the points of dispute are only in respect of the bill of costs. So points of dispute are not statements of case. They're not statements of case, but they are in respect of the bill of costs. But there are issues which in every solicitor-client assessment the court will determine, which are not in the points of dispute. There'll be firstly the determination of the cash account. That will be determined, that's not points of dispute. There would be the costs of the assessment. But the further example that I could give, and again I defer obviously to the learned cost judge's experience, is that in many solicitor-client assessments, there's an application for an assessment, and the response from the solicitor is, you're not entitled to an assessment because we've served interim statutory bills more than 12 months ago and you've paid them, for example. And so what often happens in the SCCO is that there's a preliminary issue to determine whether there will be an assessment. And that is a preliminary issue which is part of those proceedings, which will be determined in terms of the costs of the assessment or the costs of the proceedings at the end, but is not determined on the basis of points of dispute in the bill, because it's not about whether the bill is reasonable or not reasonable. It's a fundamental point about whether there should be an assessment at all. So it can't be right, in my submission, that the proceedings are solely to do with or solely concerned rather, with the mechanics of the assessment, because if that were right, then all of these arguments, which, again, I'm not going to give evidence, but all of these arguments which are regularly deployed, that's the first thing the court has to determine. It has nothing to do with the bill at all. I mean, it is worth noting. I appreciate this is not going to be a determinative point, and your lordship, your ladyship may think to themselves, well, why make it, Mr. Dunn? But I think it is worth noting that in this case, the points of dispute did address the cash account. And not only did the defendant, or rather the solicitors, not object to that, they answered the point about the cash account. There was no application to strike that out. But the cost judge, who's now the senior cost judge, didn't either suggest that that was inappropriate. It may be that there is not a provision for how disputes as to the cash accounts are formulated. And it must be said, that must be right from looking at the rules, because there isn't anything there specific to it. And that's why parties do it in the points of dispute. But as I say, even on my learned friend's lowest point, that there is a determination, and there has to be some mechanism by which the court is seized of what the dispute is. Otherwise, they wouldn't be able to determine the cash account.
I wonder if
yes,
if there is such a difficulty about the fairness of the way you put it, because if at the end of the day the result of the process is the cost judge will certify the amount in respect of the assessed costs.
In respect of the sums that are owing to and from the
Yes.
parties, a part of which is the assessed costs. Yes.
Now, but you say, well, what if the solicitor has failed to put into the costs account to the account that he's received £500. Well, not that is that when the solicitor comes to soothe the balance due to him, the client will be able to set that off and say, yes, you got the certificate, but you've received £500 that you haven't accounted to me.
Well,
Or if it's the other way around and
yes.
money is due to the client will be able to say, well, actually, you still owe me £500 and I will now issue a claim form for £500.
And that's interpreting the rules and the statute in that basis means that the cost judge would certify a cash account that he or she may not consider accurate or might know is not accurate, but it hasn't been conceded. But also that the parties the onus is then on the client in your lordship's example to resist debt recovery proceedings.
Well, there's going to have to be a factual determination, and if there's a simple issue of fact, has the solicitor received the sum or not? The client presumably has some reason to believe that the money has been received, and that's going to have to be determined in some forum.
Yes. My submission is that in that scenario, the cost judge, when determining the cash account, which again is an active process, if the client says there's been money paid by a third party which hasn't been accounted for, and the solicitors deny it, then if the cost judge can deal with that on the summary basis of determining the cash account, for example, if the client then says, well, here's the email from the solicitor where they tell me this happened, the cost judge determines the cash account on the basis that the money should be accounted for. If, on the other hand, there is a very serious factual dispute between the parties that requires significant sort of litigation potentially, then the cost judge in my submission can't certify the cash account and can't determine the cash account. So the assessment isn't finalised in those circumstances. The concept of certification by a judge has to involve, in my submission, a concept that the judge is reasonably sure, or sure on the balance of probabilities, or however one wishes to push it, that it is an accurate account. And if the judge knows it's disputed, how can the cost judge determine, if he or she is determining it, then he's actively looking at it and determining the accuracy. Secondly, if it's certifying it, it would be, in those circumstances, it would have to be the case that there would be lots of occasions where a cost judge, knowing that a cash account is inaccurate, would still certify it.
Well, knowing that its accuracy is disputed,
Yes.
which is a different thing. The cost judge is not in a position to know if it's inaccurate unless there's proof that it's inaccurate. If there's proof that it's inaccurate, he probably wouldn't do it. But if what you're saying is that you end up with the dispute going off to the Chancery Division to be fought out however long before the cost judge could actually certify what's due.
Well, my lady, our position is that if there is a dispute, and if the dispute can be resolved before the cost judge,
I suppose it can't.
as part of the determination, then that's one thing. If it can't, and those will be in very, very few circumstances, if it can't, then the cost judge, and this is the point that Miss Justice Ritchie makes in Edwards, then the cost judge, once he knows the parameters, so in this case, once the Part 18s have been responded to, the cost judge then makes a case management decision. Can this be dealt with as part of the determination under Part 46? Or is this something that needs to go elsewhere? But in either scenario in my submission, the cost judge cannot, if there is a dispute, cannot certify where there is a serious doubt as to accuracy. And my lord's example is
Sorry to interrupt you,
No.
but you say there's a serious doubt as to accuracy. It's all a bit woolly. Surely, as a matter of principle, you have to say that if it's disputed, it's either resolved then and there, or it goes off and he can't certify until the dispute is resolved, unless it looks that the dispute is specious.
yes.
Because otherwise, you end up with different shades of grey and arguments about whether or not the cost judge should have certified or not, and that then is a recipe for satellite litigation.
No, my lady is with respect right. One has to either so taking us back. This is the entire reason why we say Part 18 requests in this matter should have been answered, because the cost judge in these cases does not know what the parameters of the dispute, what the nature of the dispute is, until those answers are given. So in this case, if the answer comes back, there's no commission paid, then the dispute's gone. So there's no issue then, because it's a signed Part 18 request with a statement of truth. There's no issue at all. If there's no commission, the cost judge at that point can say, there's no dispute anymore, I'm going to certify. If it comes back another way and says there was a commission charged, but it is now being credited to the cash account, again, the cost judge can say, no dispute anymore, I'm going to certify of having determined it. It's only in cases where, if the Part 18 questions are answered and there is some grey area or argument, so for example, in this case, we paid £50 to X company, but it wasn't a secret commission. In those circumstances, the cost judge may well say to herself, I do not consider this can be dealt with as part of the determination of the cash account in these circumstances. Therefore, this will have to go elsewhere.
You can do that, can you, under the transfer powers? You transfer something to what, an issue? You transfer somewhere else? You transfer it to the county court?
Yes, to the from the High Court, from the SCCO. I mean, this is certainly the point that was. I'm not sure this has been sort of objected to, but certainly Mr. Justice Ritchie's decision.
He said that, but he didn't seem to look at the rules that give you transfer powers.
Well, earlier on in the decision, as I recall, he does, because one of the points was whether.
I'm sure you're right, but I haven't looked at that bit. It's a very long judgment. So where are we? 30 something?
It is
31.
Yes. Because what Mr. Justice Ritchie looks at is the hybrid cases, which are both can be Part 7 and Part 8, and
Where does he look at transfer powers?
my lord, I'm.
I mean, if we're talking about the sort of amount which is potentially an issue in this case, we've got an insurance premium of 240.
Yes.
I would have thought that £25 is really the maximum that could possibly be an issue. So it would hardly be worth sending that to the Chancery Division, would it? You'd send it to the Small Claims Court, wouldn't you?
That's it. I mean, but
You could.
But that's really my point, because this is why it's so prejudicial to have this interpretation of the rules and the
I understand that.
because
But Mr. Justice Ritchie is contemplating another High Court action assessment process.
well, it would the power of transfer, and I'm dealing with this somewhat off the cuff, but the power of transfer from the High Court to the County Court and from one division of the High Court to another division of the High Court is permitted. There isn't any, as far as I know. could make submissions on this in writing afterwards if you wish me to, but I don't recall any limit to the exercise of the power of
But
the cost judge.
you can certainly transfer a case,
Yes.
but whether you can transfer an issue, I'm not sure about. But
Yeah. No.
it may be that the whole thing gets transferred.
Yes. Yes. It may
to
be.
the small claims court or wherever, and then when the small claims court has determined it, it gets transferred back up to
Yes.
the
It may.
post office. That's maybe the solution.
That may be the case, but then again, it would be somewhat odd in my submission if a matter is not considered suitable for the cost judge to determine, a specialist judge to determine in these proceedings, but it's considered suitable for a small claim with all the restrictions that small claims have. I mean, in reality, breach of fiduciary duty, undisclosed commissions is not going to be a small claim.
It's also not going to be something that's usually suitable for a cost judge. It's not something that's part of their special armoury. It's something that's suitable for a judge who's used to hearing witnesses and determining who's telling the truth.
Well, I would say to that point that cost judges, particularly and there is a difference certainly in respect of inter partes assessments, but particularly in respect of solicitor-client assessments, are well used, firstly, to hearing witnesses. In, for example, preliminary issues, as I've mentioned, in respect of whether there's been payment of interim statutory bills or estimates of costs. These are points that cost judges do regularly. Again, I don't need to make this point because the learned cost judge will have a view on that. But one of the points that was made in one of the points that's made in Edwards, which was a case concerning a large number of claims. So the Edwards and Slater and Gordon cases were involving a huge amount of claims where the same points were made, and one can see at page 543 of the authorities bundle 223. What Mr. Justice Ritchie says is there's this dispute. It wouldn't be right just to simply transfer everything to the Chancery Division. What should be done? What is, and this is myself talking rather now than Mr. Justice Ritchie, but what should be done is that the Part 18 should be answered, and the Part 18 being answered will either dispose of the dispute or allow the cost judge to determine the appropriate venue. And the appropriate venue might be the Chancery Division, or it might be the Small Claims Court, although my point about that, it might be that a group of cases are put before the Chancery Division. But this all, in my submission, this all comes back to the refusal of the solicitor to answer the question. Yeah. And my submission is not that parties should be spending additional time and effort on these cases. My submission is that the solicitor knows as fiduciary that they are required to answer these questions. If they know that it's a matter in dispute and it's a matter that has to be determined, so it's in dispute in these proceedings, they should answer the questions, because to not do so simply means that a consumer has to go off on their own and start proceedings afresh. And how is that, in my submission, how is that in line with the purpose of either the statute or of the CPR? The argument, if my argument was to encourage there to be all these additional disputes and satellite litigation, then I accept that would be very unattractive. But my submission is that this is the way to avoid that to a large extent. And that's ultimately the decision, the conclusion that Mr. Justice Ritchie came to. You avoid these additional costs, these additional delays, wasting court time in other courts, because the solicitor should answer the question in these proceedings. And the reason they should answer the question in these proceedings is because there needs to be a determination of the cash account, and that is in issue in these proceedings. It's a dispute within these proceedings.
If the solicitor refuses to answer the simple question, did you receive a commission, which is not shown, for which you have not accounted?
Yes.
If he refuses to answer that question, I thought that was a pretty slam dunk basis to claim an account, and a solicitor would have only him or herself to blame when at the end of the day they're ordered to pay the costs as well as ordered to pay the account, give the account. And I'd have thought a solicitor in those circumstances, when put to that, feet are put to that fire,
Yes, yes.
is not going to find that very attractive. So I wonder whether any of this is really necessary. If you make a formal request, please inform us as a fiduciary whether you have received a commission. And if you do not ask this question, we will seek an account and ask to seek costs. What's wrong with that?
Well, the reason why that is contrary, I say, to the overriding objective is that it requires, we're dealing with modest sums here, and the concern, quite rightly, particularly with solicitor-client costs, is that the costs are too expensive. It's too expensive.
All the more reason why my lord's question would put pressure on the solicitor. I thought you were going to say, well, the difference is that a letter responding saying, no, we haven't got it, won't have a statement of truth attached to it.
Well,
whereas a Part 18 will.
Well, I'm now going to make that point, my lady, as my second point, obviously. But what the position the client is put in those circumstances, and my lord is probably right, although one can never be sure what will happen in litigation, is that despite being in these proceedings, despite this being in issue in these proceedings, and despite the cost judge being required to determine the cash account, they are required to start fresh proceedings for an account. Now, they might be able to, if we're talking about sums of £50 here, they will have to take this out of the small claims limit. It's very unlikely, it's almost impossible that the Chancery Division would be interested in this sort of amount. And the ability of the district bench, I'm not sure in terms of their powers under Part 40, what they are. I mean, ordinarily an account is heard in the Chancery Division, usually. So you are, for want of that answer, what the client is being forced to do is go elsewhere and spend more money and spend more time.
Or there's the Ombudsman.
I'm not sure that they, I mean, if for example,
if you're dealing with so little money, you could go to the Ombudsman and say, my solicitor's behaving totally unreasonably. I think he's been trousering money. He won't tell me that he hasn't. I think you should do something about it.
Well, if this court, for example, found that a solicitor doesn't have to answer a Part 18 request in relation to this, no doubt the solicitor's response to the Ombudsman would be the Court of Appeal said I didn't need to answer this request.
Well, not in the context of these proceedings, but that doesn't mean to say they wouldn't have to answer it in other proceedings.
They would have to answer it, no doubt, in other proceedings, but those are additional proceedings. And what is the point, I would ask, of these rules and statutes? The entire point is that this can be dealt with, or at least case managed in one place. But my lady's point, which I'm grateful for, is also obviously extremely pertinent. That a letter simply saying, even without the statement of truth, a refusal to answer, if there's no requirement to answer the statement in terms of the statement of truth for the Part 18 request in these proceedings, if the theoretical Part 40 claim was made, the solicitors may well answer then, but not in respect of a Part 18 request. We would have to wait until the account was ordered by the court, and that ordering an account is a discretionary matter. mean, this is all becoming, for this client, extremely complicated. I don't shy away from your lordship's point that there could be theoretically other avenues. My overarching point is, when one interprets what certify and determining the cash account means in this specific context, is the intention here that where there is such a modest amount at stake, is the intention here that the cost judge and these proceedings are essentially frozen in time while the client is forced to go elsewhere?
You can't suggest to us that even in these proceedings, this is really Mr. Turner who is pursuing the £25 on his own. This has been done on some form of collective basis, isn't it? Or this is even the way the route you're proposing is not going to be done by an individual seeking £25.
I'll turn my back because I don't know the answer to that. Well, there will be cases where there are, so Edwards and Slater and Gordon is a good example of that, where there are lots of claimants. But this, I'm told, is the only claim against this particular solicitors. There are other former clients who
Others grouped together on point, but they're against different firms.
take the. My understanding is that this isn't any sort of group litigation or group action, and it may be, my lord.
So Mr. Turner is pursuing this for the commission.
Well, Mr. Turner wants a refund for what he says is unreasonable deductions from his damages, and the damages in these cases are modest. So I appreciate the sums are modest, but our position is that's why if you have a circumstance where solicitors are obliged to answer this, then the court should facilitate the overriding objective and make them answer it. That's precisely the point. But they are modest, but the damages are modest in these cases, and these are deductions from the damages.
That's one of the points that you make. You say that given that the damages are modest, it's only right and fair that there should be a simple, streamlined process within the process that's already going ahead. And you say proceedings in this case go beyond the assessment. They include the certification of the costs account, and it's possible to interpret that as including a vehicle for making a Part 18 request. That's really what it boils down to.
Yes, my lady.
Yes.
That's yes. My lady's quite right. But,
Mr. Dunn, how are we doing for time?
I was just going to turn my back to see if I'm very grateful. The other issue, which is obviously important considering my submissions before the lunch adjournment, is the question of this additional threshold test. I don't know whether the court needs to hear from me in detail on that, but that is ultimately the basis upon which, as I set out, that this point was decided.
Your short point is, in order to seek information, you don't need to have an evidential basis for saying something is wrong, or the whole purpose of this Part 18 request is to see whether or not there is something wrong.
Yeah, well, again, my lady is quite right, so I hope I can be brief.
I mean, we come across this in other contexts because of pre-action disclosure, and there is a distressing habit amongst some judges of seeming to suggest that you can't get pre-action disclosure until you know that there is something to be disclosed, and you've actually got to show, and it becomes a completely circular argument. So speaking for myself, you're pushing at a bit of an open door on that one.
I'm very grateful for that, and that's obviously, as we put it in our written submissions, the catch-22 point, isn't it, that we won't know until something's told us. The judgment of Judge Rowley clearly states that there should be a test which is akin to the pre-action disclosure test for all the reasons that isn't supported by the practice direction or the rules, and it's not supported by any authority. I can assist further, but you have our written submissions on that.
Argue the point.
No, she didn't.
No.
The only question I wanted to ask you about Part 18 in
Yeah.
principle is what you say about what the cost judge said.
Is this in the core bundle, my lord?
Yeah,
Yes.
para 39, where what he seems to be thinking is that what Mr. Carlyle was really after was a gateway to relief under FISMA. And how that impacts on cases which have said, well, you shouldn't be using Part 18 to find out if you've got other complaints against the defendant under other causes of action.
Yes, and that is obviously a fair concern, because I accept that one can't use Part 18 in order to mount a collateral attack in other proceedings. But in this case, what the judge says is it may, such lack of disclosure may open the gateway to other remedies. But that isn't the purpose of the Part 18 request in my submission. The purpose of the Part 18 request clearly is on its face.
Well, you say that, but as far as the cost judge was concerned, he didn't actually have the questions in front of him.
No.
And he is being told by the client's advocate that a point of asking the questions is to open the gateway to remedies under FISMA.
Well, yes, the advocate is saying it may open other streams, but it's not. That's not the. What is asked for is, and this is paragraph 36, relate to commissions that have been received and not accounted for.
But the combination of the lack of the questions plus what he's been told is the purpose of the inquiry, might that not be a good enough reason for saying, well, no, I'm not going to grapple with this?
That might have been, but my reading of the judgment is that that's not what the judge found. The judge didn't find ultimately, and I would submit that if one just boils this down to first principles, if there is a secret commission that should be accounted for and credited to the cash account, then that is a matter which is obviously pertains to these proceedings, because that's what happened. But the judge's ratio, the ratio of the decision begins at 40 in my submission.
All right, well, I'll put the point to you and I've got your answer.
Okay, thank you. Milena Junior Miss Gopal was going to deal with the procedural point and if necessary, the Gibraltar points.
Sorry, which procedural point?
So the question of whether the cost judge was right or had the ability to refuse the Part 18 on the basis that he didn't have the questions in front of him.
Yeah.
I keep calling it the procedure point, even though my lady has said it's not a procedure point, so I apologise. Thank you.
Yes. Right, Miss
Thank you.
Gopal.
My Lords, my Lady, this is now I think quite a short point, but really boils down to this, is what we say is that the cost judge knew the substance of the requests that were being made, notwithstanding the fact that the physical document was not in front of him. The reason we say that is we've got as a starting point what was in the claimant's skeleton argument before Costs Judge Rowley. That is in the supplementary bundle at page 168. And it's paragraph 16,
Yes.
where the submission that's made is all but identical to the questions ordered to be answered in Edwards, and we know that Costs Judge Rowley was in Edwards. We know that Costs Judge Rowley then proceeds to deal with the substance by reference to his own earlier decision in Brown and JMW, which the court's already been taken to So we say that it's quite clear that he knew what the substance of the questions were, otherwise he wouldn't have been able to engage with any further substantive points on the threshold test at all. And one of the points made against me in the authorities that are cited refer to the fact that, well, it isn't for the cost judge to request the Part 18 questions or to perfect an imperfect scenario, imperfect case. The response to that is the correspondence that occurred between Mark Carlisle for the claimants, Mark Brighton and cost judge following the hearing. And partly, I think my learned friend has taken the court to that correspondence already, but I highlight page 174 of the supplemental bundle, where Costs Judge Rowley says, if when I'm drafting my decision there is any point on which I feel I will benefit from further submissions, I'll be in contact, and doesn't do so at that juncture, but obviously asks for the Raubenheimer skeleton to deal with points that were raised on certification. So that's really our point on the fact that the physical document was not in front of him. The Gibraltar point hasn't really been pressed, and I'm not sure if the...
Why does it matter?
I'm not sure it does, my lord. We have the answers. We actually had the answers as of, I believe, the consequentials hearing.
Yeah.
So
I mean, normally, if things don't matter, we don't decide them.
I appreciate that. So I can leave it there. Thank you.
Right. Ms. Bedford, do you wish to reply?
My lord and my lady, I do. I'm going to tell you that I have 10 points, which is probably going to put the fear of God into you. But they are short points, so I'm hopeful that they're not going to be too abrasive for you to listen to at 10 to 4 in the afternoon. First of all, this morning, my lord, you asked me for the situation in respect of the statutory position pre-1843. The industry of my junior sat behind me has very helpfully pointed out we do actually have it within the bundle. It's summarised within paragraph 21 of the Lisa Jones case, which you'll find at 571 of your bundle.
Yeah. I think Dr. Bristol also gives us a positive history at the end of his book.
Absolutely does. It goes slightly, I took you to the potted history, of course, which Lord Hamlin put forward in Menzies, but you're quite right, it didn't quite go far enough. So it's 571, forgive me. And what you'll see importantly from that paragraph is that even then, when one looks back to 1605 and the statute of Jack III, I'm not pronouncing that correctly and I apologise, but it is exactly the same.
James,
Thank
third year
you.
of James the First.
There we go. You can tell I was not a history scholar.
Hence Jacobites. Yeah.
So, my lord, that answers that point. May I deal secondly, which is possibly slightly more involved, the appeal before Mr. Justice Sweeting and the development of it. I took you to the skeleton argument of Mr. Carlisle, which was before the court in respect to the appellate on that case. I take you to my skeleton argument, which you'll find at 98 of the core bundle, which sets out precisely that this issue you'll find it at page 98, and then if you go over to 107, you'll see at paragraph 44 the 3 points which were put in respect to the application in substance in any event. The reason that it doesn't appear until paragraph 44 is, as my lord has pointed out, the Part 18 questions weren't before Judge Rowley, and the only reason they were even put on the appeal was in response to this skeleton, where I pointed out at paragraph 13 of page 102 that it was a curiosity that they weren't even put on the appeal.
Yeah.
So as a consequence of that, the Part 18s weren't actually filed until 2 days before the appeal. So at that point, the appeal was very much on the footings of a case management decision, which was fully within the power of the court, the reasons that this court has pointed out, but alive to the notion that there was a possibility that the court may say, well, the appeal can be allowed, but then what are we going to do about it? The point was developed and it was there. Just on that last point, there was a further curiosity about the judgment of Mr. Justice Sweeting, which perhaps is not immediately obvious. There was a 9.5-month delay.
Which is obvious on the face, on the first page of the judgment.
And there was a successful JICO complaint
Yes,
made.
indeed, I knew that
Yes.
too.
Yes.
Aware of that.
So as a consequence, what happened was during the appeal, which seems to have been forgotten by the time the judgment came around, Mr. Justice Sweeting said in terms, well, we're probably going to just deal with it on the basis that the Costs Judge was entitled to decide that he didn't, the Part 18s weren't satisfied because they weren't before him. But Miss Bedford, what are you going to do with that if I deal with it as first instance? You'll see this from page 165 of your core bundle. You'll see there from Mr. Justice Sweeting. Yes, I mean, that may be where we end up. But I think on an appeal it would be difficult, perhaps, subject to anything that may be found in reply, to say the judge was wrong in this respect. Plainly he was not. He did not have it in it being the Part 18s in front of him. Unless I'm persuaded otherwise, that's a very unusual position to be in. There's then more submissions from myself, and one goes over the page to 166, where I raise, well, this may have cost implications. But Mr. Justice Sweeting, on the first section of his interjections, well, I think this is what we will be doing. We would be saying, in relation to this aspect of the appeal, the conclusion is as follows: the master was entitled to make the point and to deal with it on a procedural basis, as an obvious procedural basis as he did, notwithstanding that this is the result of the appeal, but there is no point in going back, and our view today is that we can just hear it afresh. Now, when I came to draft the appeal grounds last year, we had the appeal and the judgment which did not reflect what was in the transcript. So it has been put on the basis of a second appeal, which of course put my client to the higher test of having to show that there was a principle that this court had to deal with. But nonetheless, as my lord put to me earlier, nonetheless PTA of course was granted, and so we are where we are. But I think it important just to put before the court the development of how these points have come through. They are relevant. Thirdly, very quickly in relation to the MOJ report, I'm not entirely sure how this has been deployed, and I suspect it's entirely my error. Thank you, my lady. Yes, if it's been deployed as evidence, then that obviously
Background
has
mischief.
If it's as background, then perhaps I can suggest this also as a relevant aspect to the background, is that actually what's recorded at page 706 of the bundle is simply evidence that has also information that has been received in. Oh, sorry, forgive me, it was 70. I've made a wrong note of the paragraph. Forgive me, it's 669. We've also received some evidence, and then if this is true, and then it goes, it is suggested that the difference between, and then that just comes where it says about the commission. It's merely a suggestion, it goes no higher than that. It certainly wasn't a finding by the MOJ. But what I would also invite you to take into account as background is that JG solicitors, the solicitors for the claimant in this appeal, were one of the respondents to this report and will have put a response in which potentially could have underpinned that paragraph. It's a difficulty on the evidence, my lord, if it is to be taken as evidence. Otherwise, in terms of the background matrix of fact, 2 points. Number one, JG. The other point being, of course, that external matters such as MOJ reports are not to be taken into account on the interpretation exercise. Fourthly, in respect to the function of the practice direction at 6.6b, if I could just take the court to that for a moment, please. That is at page 114. What one has here in respect to the practice direction is a very similar situation to what one has with section 17, that it's sequential, one moves through it, it's a cradle to grave situation. So there's talk about the terms that the solicitor can agree at paragraph 6.1, talks about the indemnity basis of the assessment, and then it moves through to the breakdown. Now, obviously the breakdown doesn't get to be served unless there has been an order for an assessment itself. And then we have a paragraph B, which my lord took me to this morning, in applications under section 70. So the cash account is still situated, as we know, within section 70. But Mr. Dunn makes the point that there is excluded payments which are made in satisfaction of the bill, or any items which are claimed in the bill. I say the reason for that is really simple, is that when one is determining the cash account under 619, which sequentially is the last step in the process, one at that point under subsection A has to take into account what the bill has been assessed at. 6.6b says that you have to leave out of account matters for the bill at that point, which of course is the bill that it's claimed. So there's potentially going to be a difference between the bill, the amount in the bill is claimed, and the amount in the bill is assessed. So what one does is, in the cash account, one doesn't take into, at the point it's served, which is at the beginning of the assessment, one doesn't take into account matters which are payments towards the bill, because one takes into account the amount of the bill following assessment under subsection A in 619. So that is the reason that it is excluded, effectively so that the correct accounting function can take place. Because if the bill, again, is claimed at £1,000, that's one thing, but actually the court in determining the cash account is concerned with what the bill is assessed at. So if that's £500, then the figure of £500 is the relevant one, not the £1,000.
Is that an answer to Mr. Dunn's point about the cash account including items that are not, strictly speaking, within the bill?
Yes, because they could be assessed down. That's the exact point.
That's the point.
Yeah, that's the exact point, because it's the practice direction again is sequential.
Yeah.
So the point that it comes in. Thank you.
You're presumably going to deal with his point that what happens if the damages are misstated, or the cash account includes something which is in the bill but it shouldn't be in the cash account.
I am going to deal with that, absolutely.
All right, you deal with it when you're
you.
ready.
I'll deal with it now. You've raised it.
No, it's all right. You've got
It's
you've got your 10 points, so probably in
So the damages, of course, that's not what the function under 619 is concerned with. That is the point that my lady put to me this morning. Matters of damages aren't to be taken into account when calculating the determination of the cash account.
Well, they are in this case. I mean, they feature in the cash account.
That's
First item.
It is, but in my submission, the interpretation of what is permitted under the rule cannot be driven by whether my solicitors have put an item in a cash account as a matter of fact. It's not helpful. And it's not determinative, and in my submission it doesn't fall in any of the canons of statutory interpretation at all, so it is to be excluded. But in terms of simply putting it there, in terms of the damages, that, as I say, under 619 subsection A through to D, isn't a matter of which the court, the costs judge, is going to be concerned with when working out what is to be certified due or owing to the solicitor, and then features in the final cost certificate. It's simply not there. It's not a function of the court in that respect. And those are for the reasons that I submitted this morning about the distinction and the difference between whether this is a narrow factual exercise or whether on Mr. Dunn's submissions it is a more wider exercise, taking into account absolutely everything. I suppose it goes to the point that I said about whether the court, the cost judge, is going to be particularly concerned with whether the rents that have been received are correct or not.
What about the point, though, that Mr. Dunn makes, regardless of whether or not it's wrongly put in the account, but let's suppose that there is a figure which should go in the cash account. Let's suppose the solicitors have received some money which they should be accounting for to the client, and for some reason it's not in the cash account and should be. What's the position there?
Well, that would be a dispute in respect to the cash account, which falls in my submission squarely within the understanding of we've seen in the authorities from Jones and James through to Re Neville. I know that my lord put the point to Mr. Dunn that while because there are no the scope and function of points of dispute go to items in the bill, perhaps there's no ability to put these items in terms of objections anywhere. Mr. Dunn made the point, well, actually on a Solicitor Act assessment, sometimes we have to deal with things that are outside the bill, and he utilised the example of, well, there's going to be a dispute as to whether anybody's entitled to an assessment, how do we deal with that? Well, the straightforward answer to that, of course, is that until the order has been made, there is no assessment. So consequently, we are not in the jurisdiction or the procedural code which is contained within 46(9) or 46(10) in terms of the Solicitor Act procedure. We're simply not there. And so what happens when the Part 8 claim form is issued is that there is a request for an order. And then as a secondary point, there is also a request for the assessment. So what you'll see exactly on this claim form, as my lord took me to this morning, is exactly those two things. So at page 82, first of all, the claimant seeks an order that the costs be assessed pursuant to section 70. And then the second point of the order requested is that such assessment to be restricted, as my lord put the point this morning. So in those circumstances, there is often a dispute about limitation, which of course is what this court saw in
stage 1.
Exactly, but it exactly.
So there will be a dispute about the entitlement to an order at all.
Yes, that's exactly what it is. But it's stage 1, my lady. You have it exactly so. And it's before the assessment. But once we get into the assessment,
we've seen Costs Judge Rowley's original order, which gave the directions.
That's exactly it. That's the standard form order. I'm sure that my learned assessor will be able to tell you that. He's nodding at me, so I'm pleased that I haven't misremembered that. That's exactly it. And actually, as I said, we see these types of, this court in particular, saw these types of arguments exactly in Menzies. It was a limitation argument,
Yes.
and it occurred before. So in my submission, that's the point that one deals with it. I think that was actually point 6, so I'm going to move back, if I may, to point 5 that I had, thank you. We're halfway there. In terms of the function of part 70, oh sorry, it's late in the day, I've got my numbers wrong. In terms of part 67, if I can just ask you please to turn that up, that is behind tab 7. I say this doesn't assist my learned friend at all, and actually is probably a point against him. What one sees under part 71, as my lord pointed out, that the scope and interpretation is identified, but otherwise the jurisdiction is engaged. And one sees at subsection A that what one can do is different types of forgive me, subsection 1 says this part contains the rules about the following types of proceedings. So the differential that it encapsulates different types of proceedings, as it says on its face. Subsection A deals with the order for a solicitor to deliver a bill or a cash account and proceedings in relation to money or papers received by the solicitor. That is defined under rule 67(2). And that particular part of the rule in my submission actually goes to a different section of the Solicitors Act. It goes to section 68. Thank you. So actually, what we're concerned really is subsection B, which actually is over the page in 67(3). That's the assessment provision. So what Mr. Dunn relies upon is the aligned procedural code operative upon an entirely different section of the Act. And actually, one of the reasons why there is a differential is one, as we've been through ad nauseum, the practice direction at 6.6a requires a cash account to be delivered upon service of the breakdown of costs, which is in the assessment. So that's where the cash account comes in. This provides a standalone procedure outside of the assessment and actually at the junction even when the solicitor delivers their bill. So I say that simply doesn't help when one is in an assessment. Seventh, if I can just deal very quickly with the transfer to the county court under practice direction 40. I'll just invite the court to consider the practice direction in totality. What it does at practice, I appreciate this isn't before the court. I can either just direct you to the rules, I'm happy to read it out, whatever the court would find more useful.
Summarise it if you can.
Yes, okay. Well, it contains a procedural code for dealing with accounts in respect of accounts in this instance. And the management of proceedings is actually quite wide. It's under subsection 5, and the court may at any stage in taking the account direct a hearing in order to resolve an issue. So that's how it does it. The accounts under subsection 9, it can be dealt with in both the county court or the High Court, which I think was one of the points that was put this morning. And then in terms of the consideration by the court, it's at paragraph 12 and paragraph 13. Paragraph 12 is for the purpose of considering it. The court may direct it to be investigated in any manner. So it does seem to be quite a wide jurisdiction. And then a notice of the decision. So I would suggest that the notice of the decision, as opposed to listing it for a hearing, is more akin to an understanding that it will be decided on the papers.
Yeah.
And if I'm right on that, then it must be actually not the most expensive, convoluted, complex procedure that Mr. Dunn paints it as. It's a streamlined code that's intended to be used for this purpose, which culminates in my submission, proportionate, reduced process for resolving these exact types of disputes. And to a large degree, my lord, that aligns in my submission quite nicely with the warning that was given by the Master of the Rolls, Lord Voss, in Belsner, which you'll find at page 720. Just to summarise, it's also the point that
He was saying go to the ombudsman.
that was exactly what I was going to say. It's my lady's point of, well, there is a process. It's under part 40, it could be under part 64 as I suggested, or one can go to the ombudsman, but what one is doing is not expanding a Solicitor Act assessment in the way envisaged in order to be able to be in a regime which is cost bearing.
Yeah.
Again, compare that to the county court process if this was in fact a small claim. So whilst there is the merits point which operates against me, in my submission there is a merits point which operates against my learned friend, which is the expansion in order to deal with this, to claim the additional costs, which is set out within Belsner, and it's also reflected within Heritage.
Well, that's also what the court said in Herbert, that they weren't going to expand the scope of a Section 70 assessment.
Yes, absolutely. That's 3 very strongly constituted courts of appeal, I would suggest, that are all singing from the same hymn sheet. That actually was my 8th point. In terms of the Part 18s and the positive threshold, in my submission, what Judge Rowley was actually speaking to was the position in Hennessy against fishing expeditions, which is a slightly nuanced point, and I accept that. But the positioning against fishing expeditions in my submission was the argument that was before him, because that was the response in the replies. And that there is an opera, which was what my lord put to Mr. Dunn, which is that irrespective of whether there is a positive case or not, there is a very strong position against asking questions which are intended to elicit responses for different proceedings. And then if I can just finally deal with perhaps the point that my learned friend Mr. Powell made so eloquently, which is what the judge knew or what he did not know, and in particular drawing on, in her submission, reliance upon, well, he was sitting as the first instance decision in both Edwards and Brown. It may be instructive. Edwards was decided 2 years before this case. The notion that a judge can keep in their head information from 2 years before in a busy list, in a busy court, in my submission is just frankly absurd. And I do use that in those strong terms. Brown was about 9 months, 10 months before. And this, of course, goes back to the point that I made this morning, that if applications of this nature are going to be made, one has to do them properly and in compliance with the rules. Otherwise, in my submission, one can't come back to the court at a later date and say, well, the judge obviously knew exactly what he was doing because he ought to remember something from 2 years before.
You may say it's not just a question of what the judge knew. The person who's being questioned ought to know what questions are being asked.
Well, I don't think I can go as far in this case because they were served back in 2020, which again was broadly 2 or 3 years before the hearing itself. As I said this morning, the Part 18s just simply didn't feature at all until 2 days before.
It was an ironic situation that both parties knew perfectly well what the questions were, but the poor judge didn't.
And can he really be criticised for making a case management decision in circumstances where he does not know, particularly in a jurisdiction, and I do say this about Part 18, where the test has to be applied against every single question. It's not that the test is applied cumulatively, it is applied sequentially through every single test. How on earth can a judge decide that if he doesn't know what the questions are? And in my submission, I do again use this word, and it is absurd to suggest that a cost judge or any judge ought to be put in that situation. But yet that is the situation that Judge Rowley, senior cost judge, found himself in. He was, of course, undertaking a case management exercise, and I appreciate that I was not called upon to speak to either Part 18 nor indeed the case management aspects of this appeal, but I do say that they loom large. I appreciate that it may not be something which is a more complex point or indeed a point of principle, but nonetheless, interfering with a case management decision of a judge at first instance is a high bar, and it's a high bar for a good reason. So as Mr. Justice Sweeting himself referenced within the judgment, the transcript, not the judgment, was that really a case management decision which could, on the proper principles, be interfered with?
Yeah.
In my submission, it was not. I have taken you through my 10 points. I took 20 minutes, please forgive me. I suppose it's 2 points, 2 minutes a point, unless there is anything else that I can help anybody on.
Thank you very much.
Very grateful to your time, thank you.
My lords, my ladies, your heart may sink as I rise, but the point that my learned friend just made lastly was not a point that was obviously made this morning. So my learned friend has raised points about the fact that the questions were not before Judge Rowley that I haven't been able to respond to, and I just have 2 very short points that I want to make, which will take less than a minute.
Has got an argument, but if you thought that wasn't being pressed, then fair enough. 2 short points.
The first is that Judge Rowley goes on to consider the merits of the Part 18, and it's axiomatic in my submission that he would not have been able to do that if he didn't know the nature of the questions. The judge obviously reread his decision in Brown because he imports those paragraphs into his decision. But the second and more wider point about this is that the judge specifically says, I don't need any more information. He's in contact with the parties by email after the hearing, and there's no suggestion that he's in any difficulty as to knowing what the questions are. I appreciate that the judge says there's a procedural issue in that he should have them before him, but certainly if one looks at the post-court correspondence. Those are my only 2 points.
Right. Well, thank you very much, both of you, or 3 of you, for your arguments. We will reserve our decision. As you know, we are very close to the end of term, so don't expect it before the long vacation. You will get a draft in the usual way. It comes with a strict embargo, which means what it says, so it can be shown only to those on the distribution list, which the court already has. It will be your opportunity to correct our English, not to introduce new arguments, nor to challenge our reasoning. And we would hope in the light of the draft judgments you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions. We will make the form of order that we consider to be appropriate. The hand down, when it comes, will be done electronically by distribution to the parties and released to the National Archives, so there will be no need for further attendance. Thank you all very much.
Thank you.
Court rise is able.